We're going to go ahead and start, and I want to thank our witnesses. Not yet. This is Paul's first time in the second time? First time in the chair, replacing Gib Mullen. So Paul, thank you for your good work, but I just wanted to let people know that they're witnesses. I appreciate all of you coming here today, and one of them, extraordinary circumstances, Mr. Boulard, who actually could have attended the NCAA final game last night and is a UConn fan and from Connecticut. So that's a bigger sacrifice than we usually encounter here.
I gave my tickets up to be here, Mr. Chairman.
Yes. Now, some of us are doubting your ability to make good decisions. But we are thankful that you did that. And I will introduce all of you before we actually start your testimony. And so now I'm going to start my opening statement. And good morning and welcome, everyone, to today's hearing called Trolling for a Solution, Ending Abusive Patent Demand Letters. As Thomas Edison once said, to invent, you need a good imagination and a pile of junk. That may be true, but I would also add that you also need to fight for your invention because, as Thomas More said, it is naturally given to all men to esteem their own inventions best. Now, in competition of ideas, whether we are talking about multinational company that spends $8 million per day on R&D or an inventor with a workshop in his basement, the Constitution treats intellectual property equally. So let me start by saying that we must respect the arrangements small inventors need in order to force their patent rights. And while we're at it, let's emphasize that not all patent assertion entities are trolls. The role of patent assertion entities is very important for small inventors who lack the resources to enforce his or her own property rights. Taking away or degrading the flexibility to assign enforcement rights would do nothing less than encroach on inventors' constitutional right to exclude others from infringing their property rights. With that said, what we address today are instances where bad actors extort money from innocent parties under the pretense of asserting intellectual property rights. This kind of activity belongs in the same family as other type of unfair and deceptive trade practices. Our job is to separate it from legitimate right assertions. In order to do so, we have here today a diverse panel of witnesses whose testimony gives us a variety of perspectives on the issue. Already we are seeing a set of potentially conflicting considerations. First, patent enforcement differs across industries. According to Unimed testimony, it considers listing patent claims in demand letters to be standard procedure. Caterpillar, on the other hand, would find it difficult in some situations to list the exact claim at issue because it often lacks access to the potentially infringing product. Second, some argue that we should only address letters sent to end users of patents. Now, this may fail to address situations like the one in Unimed's testimony where a small inventor was slapped with an abusive demand letter just after clearing an FDA approval process. Even so, the majority of complaints on this issue appear to come from the end users who are not versed in patent law. I will not exhaust the issues before us today, but I want to clarify one thing. Some may say that legislative action to curb abusive demand letters would devalue intellectual property rights generally. I disagree. In fact, it remains that these bad actors are arrogantly manipulating the intellectual property system and getting away with it. Several state attorney generals, including John Bruning of Nebraska, have brought suits under their consumer protection statutes, tools, and thus have far proven difficult to use. As a result, many states are working rapidly to update their laws. There is something to be done here, and in order to get it right, we'll need the assistance of all of the stakeholders and witnesses here before us today, and I thank the witnesses for being here, have 1 minute. Does anybody want it? Hearing none, I yield back my time and recognize the ranking member of our subcommittee, Ms. Sikowski.
Thank you, Mr. Chairman, for holding this important hearing on patent assertion entities, also known as patent trolls. And like you, I want to develop a solution to this growing issue and look forward to doing so in a bipartisan manner. Trolls assert that the patents they hold have been infringed upon, sending vague and threatening letters to hundreds or even thousands of end users of products, typically small businesses or entrepreneurs. Those businesses are told that they can pay the patent troll to continue using the technology. Considering the cost and resources needed to vet and fight a patent infringement claim, many small businesses choose to settle the claim by paying the troll. Others investigate and fight the claims, draining precious resources and stunting the growth of their businesses. It costs patent trolls virtually nothing to send patent demand letters, but it can be incredibly lucrative, and business is booming. In 2011, patent troll costs U.S. businesses an estimated $29 billion, and the number of defendants in patent infringement lawsuits increased about 130% from 2007 to 2011, according to the Government Accountability Office. At best, patent trolls are misleading. At worst, they are extortionists. This is fundamentally a fairness issue. As a subcommittee charged with protecting consumers and promising fair business practices, we must take action to reduce frivolous patent claims. I am glad that the FTC, the Federal Trade Commission, is using its existing authority to better understand the nature of patent assertion entities and the demand letters that they issue. I look forward to the Commission's analysis, which I believe will be instructive as we decide how to curb trolling. Nonetheless, while we wait for the FTC review, there are steps that we can and should take now to combat patent trolls. I believe there should be more transparency and minimum standards established for patent demand letters. There are many ideas about how to increase transparency, including proposals to require the public disclosure of egregious patent demand letters. There are also suggestions as to the minimum information that should be included in a patent demand letter, including the patent allegedly infringed and the technology used that allegedly infringes on the patent. However, it is vitally important that we approach this issue with the recognition that many patent infringement claims are reasonable efforts to protect intellectual property. We also need to be careful to make sure that universities, research institutions, and others that develop and hold patents but may not develop products for sale are not labeled as trolls. In fighting trolls, we shouldn't undermine the ability of innovators to develop and defend their patents. While our witnesses today come at this issue from a wide variety of perspectives, it was interesting to read in their prepared testimony that each believes that this is an issue in need of attention. The details of whatever legislation this committee puts forth will be incredibly important, but the fact that our witnesses unanimously agree that we have a problem is an important start. I look forward to hearing their perspective about how legislation should be structured to make sure that patent demand letters are more fair and transparent moving forward. Again, thank you for holding this hearing today, Mr. Chairman. I yield the remainder of my time to Mr. Is he here? Mr. Welch.
Thank you very much. I'm getting the opportunity to introduce our Attorney General in Vermont, and we're very proud of Bill Sorrell for the leadership that you've provided, and also the other panelists, too. This is an incredible issue, and Bill Sorrell was very responsive to a lot of the folks that range from businesses that got these unbelievable stick-up letters to nonprofits where these parents had raised money in the community to set up a group home for disabled kids, and next thing you know, their threadbare budget is being threatened by these letters demanding payment for, they couldn't figure it out. And Bill, you worked with Jerry Tarrant and others and with our legal community there. It was very responsive, and you're working with your fellow Attorney Generals. Mr. Chair, our Attorney General was the former head of the Attorney Generals. Received numerous awards. I'm not going to bore everybody with what they are, but I'll tell you, they're good, and a lot of us wish we had them as well. Leader in tobacco legislation, humane society issues, champion for kids, taking the fight about prescription drug medication abuse and abuse of drugs in our state. So it's great to have Bill Sorrell here, and it's great to have you on the patent troll issue, and we look forward to working together to try to deal with this. Thank you. I yield back. Thank you, Ranking Member Schakowsky.
Now yield back.
All right. Does anyone on the Republican side want time? I have to talk slow to draw this out. Anybody want to talk about the game? All right. Seeing no one taking our time, then Mr. McNerney, you are our resident patent holder. Would you like the minority's time?
I sure would.
That's your, but you're the only one. You're
Okay.
the expert. You,
All right, thank you, Mr. Chairman.
You're recognized for 5 minutes.
I appreciate your calling this hearing. You know, if you hang around here for long enough, you see the advertisements in the Hill Rags about patent trolls taking more and more money over time, and those will get your attention. If you walk, take the Metro, you see every so often at the Metro stops big advertisements. So this is clearly an issue, and the fact that the so-called patent trolls are demanding stick-up letters, as my friend from Vermont said. It's an issue. We need to address it. There's a general understanding that this is a problem, and I'm glad to see that. I'm glad to see this come up in hearing so that we can hear your inputs, how we can move forward together, how we can best address this issue. As the chairman said, I have patents. One of them is a fat wire patent, and the other is a software patent. So I kind of understand where we could be with this issue. I understand as a small patent holder how difficult it would be to assert your rights against a large corporation, if that comes to that. So there is a place for patent assertion entities. I want to see that preserved, but we want to see that the sort of stick-up nature of this is curtailed. So it's a balance. It's important to have a well thought out and meaningful bipartisan discussion. And I think on this particular issue, we have a good desire to work on a bipartisan basis. So we have an opportunity to make it better. And I'm hoping to be a part of that. I'm hoping that your testimony can help guide us on the decisions that we need to make. So with that, I'm going to yield back, Mr. Chairman.
You still have anyone else? Yeah. All right. So, Mr. Schultz.
Would either of the other members of the committee, Mr. Matheson or Mr. Barrow? No? Okay, thank you.
Gentlelady yields back, and so I want to introduce our panel now. Bill Sorrell is one of our resident expert witnesses from the AG's office, and we appreciate you being here today. For those of you who haven't testified, and before us, we go stage left to right. So Mr. Sorrell, as Attorney General of Vermont, will go first. Then we now have Mr. Brouillard, the person who gave up his tickets last night to be here, and your sacrifice is massive and well appreciated. You represent the Savings Institute Bank and Trust Company on behalf of the American Bankers Association. Then next to him, Mr. Scarvan is Deputy General Counsel, Intellectual Property for Caterpillar. Appreciate your appearance. Then Mr. Schultz, or as we call him, Jason Just-in-Time Schultz, Associate Professor of Clinical Law, New York University School of Law, and we understand it's been a difficult morning for you, and we appreciate that you undertook these heroic efforts to get here today. Thank you. Then we have Mr. Mark Chandler, Senior Vice President and Chief Compliance Officer of Cisco Systems, who has great experience with these type of demand letters. Then last, Mr. Michael Dixon, Ph.D. Dr. Dixon is President and CEO of Unimed Corporation, University's holding business of all of the patents generated by the university. So at this time, Mr. Sorrell, you are recognized for your 5 minutes.
Thank you, Mr. Chairman, Ranking Member Schakowsky, members of the subcommittee. Thank you much for the opportunity to appear today and speak about an issue that's of great importance to the nation's attorneys general, as evidenced by the fact that 42 offices signed on to a sign-on letter that we sent to the Senate, drafted by General Bruning and myself in February on these issues. Much of the work in the House and in the Senate on assertions of patent infringement have related to abusive litigation tactics. But the truth of the matter is that's just the tip of the iceberg. And I want to talk some today about the iceberg, the roughly as much as 99% of cases that don't result in the filing of a civil complaint. And so I want to talk about, for example, Lincoln Street, Inc., a small nonprofit in Springfield, Vermont, with 16 direct care workers, 12 or 13 administration and support staff that provide home care to developmentally disabled Vermonters. In the fall of 2012, Lincoln Street received a letter from one of the roughly 40 shell subsidiary corporations of a parent corporation by the name of MPHJ Technology Investments, LLC. Paraphrasing, the letter says, we own patents X and Y. We believe you're in violation of them in that you are scanning documents and sending those in email through a computer network. Please be in touch with us within 2 weeks and prove to us that you're not infringing our patent, or talk to us about resolving this and paying licensing fees to us. We've had a very positive response around the country from the business community, many companies agreeing to pay us $1,000 per employee. A couple weeks later, a second letter comes, this time from a Texas law firm by the name of Farney Daniels. It says, we've been retained because you didn't respond to the first letter. This is serious. We hope that we don't have to get to litigation, but unless you're in touch with us forthwith and resolve this amicably, it's going to be trouble. Please take this seriously. And then there's the third letter, a couple weeks later, also from Farney Daniels. This one attaches a draft federal court complaint against the recipient of the letter and says that if you don't resolve this with us within 2 weeks, we will, quote, be forced to file a complaint against you. If you're not in touch with us within 2 weeks, quote, litigation will ensue otherwise. Well, it wasn't just Lincoln Street that received that letter in the fall of 2012. We ultimately learned that 75 small businesses and nonprofits in the state received letters from one or other of the shell subsidiaries. And when we filed the first of its kind in the nation lawsuit in the spring of 2013 against MPHJ, as of that time, not one lawsuit had been filed in Vermont, nor had, to our knowledge, a lawsuit been filed by MPHJ or any of its shell subsidiaries anywhere in the country. The Federal Trade Commission, in a draft complaint against MPHJ, has looked outside Vermont, and in its draft complaint says that one of the 80 or more shell subsidiaries of MPHJ sent demand letters to 16,450 small businesses and nonprofits in all 50 states in this country. So that's part of the iceberg. Rest of the iceberg, or other parts of the iceberg, are demand letters to smaller financial institutions saying your ATMs use the web, they're in violation of our patent. Others go to local coffee houses that have free Wi-Fi. We have patents, you're a violation of those, please pay up. We filed our lawsuit in state court. We were immediately removed to federal court, and MPHJ has said, one, we're totally preempted because this is a patent matter. You can't be enforcing your state consumer protection acts against us. And second of all, you lack personal jurisdiction over us because all we've simply done is asserted patent infringement, and that doesn't subject us to personal jurisdiction. We also enacted in Vermont a statute on bad faith assertions of patent infringement at the request of various well-known Vermont companies, and Utah, Virginia, Wisconsin, and Oregon have followed suit and adopted their own statutes. There are many others considering it. We hope that the Congress will take action, have more transparency in this arena, and evidence at the time of the assertion of patent infringement of any other proceedings or court matters that have ruled upon the patents in question. We want express statements that the states are not preempted and that we have personal jurisdiction for those that blanket our states with these assertions of patent infringement. I've got 21 seconds left, but all right. Oh, sorry, I read it wrong. Thank you very much.
Thank you, Bill. Mr. Brouillard, you are now recognized for your 5 minutes.
Thank you, Mr. Chairman. And Ranking Member Schakowsky, thank you again for having us, giving us the chance to come and present our information to you today. My bank is a $1.3 billion community bank that's been established since 1842. We serve Connecticut and parts of Rhode Island. Obviously, the U.S. has a robust patent system which protects the rights of legitimate patent holders, and we believe those rights should continue to be protected. Patent trolls, however, as we've heard, abuse this system and are serious threats to small businesses, banks, and credit unions throughout the country. For the cost of postage, a little stationery, and some time, these trolls use unscrupulous tactics to extort licensing fees from companies too small to pay the cost to defend themselves. The claims are often intentionally vague and based on shaky legal standing. However, when confronted with threats of expensive litigation, many banks, especially smaller ones, find that their only option is to settle, rather than paying the millions of dollars it may cost to defend against extortive claims of patent infringement. I've seen this firsthand at my bank. In January 2013, a patent troll targeted my bank with a very vague letter, 1 page, claiming that they had conducted an investigation and that our ATMs operated in a way that infringed upon their patents. Their letter included an exhibit which listed 13 patent numbers, purported to be patent numbers. So we had a list of 13 numbers, 7-digit numbers. That was the extent of the information provided. They demanded a sublicensing agreement, and as Attorney General Sorrell indicated, we had 2 weeks to comply. 30 other banks in Connecticut received that same vague notice, one of which included a bank that did not even have any ATMs. So there was obviously no investigation ever conducted. The pattern of these trolls is to send demand letters, threaten or even file lawsuits, and require a response within a short period of time. By forcing these settlements, they use these actions to intimidate their other targets. In fact, 2 years before we received our demand letter, this same troll brought suits in other New England states, and because of fear and lack of resources, over 100 banks quickly settled. The following year, 80 letters were sent to Maine and Massachusetts banks. They too ultimately settled. All of these letters were mailed, in fact, after a federal circuit court upheld a lower court ruling invalidating the primary patent. Many of these banks ended up settling and paying their so-called sublicensing fee as opposed to contesting the issue because of the cost. In some respects, in Connecticut, we were lucky. We had learned about the troll having done its work earlier in the other New England states, and we also had the advantage of hearing about some of the rulings that were coming out of the courts against this particular troll. For my bank, the cost would have been $27,000, which at the time represented about 10% of a monthly earnings for the bank. For the 30 Connecticut banks targeted, had we paid together, the amount would have been in excess of $300,000. Even though the courts have invalidated the patents, this has not stopped this particular troll from sending demand letters and bringing legal action against other banks in other states. I'm aware that there have been additional suits filed even this year in New York and New Jersey. We thank Congress for seriously addressing this issue and commend the House for passing H.R. 3309, the Innovation Act, which begins to address the issue. But we feel this is just the first step and more can be done. Chief among these is to require transparency in all allegations of a patent infringement, including details about the patent, how the target firm is infringing on it, who the real owner of the patent is, and whether the patent has expired or been invalidated. This would help put an end to some of the abuses while protecting legitimate patent holders. Other requirements we recommend include a registry of demand letters requiring bad actors to reimburse the small businesses for all fees and costs, including the cost to defend themselves. Vendors who supply technology and equipment should be made to defend their products against patent infringement claims. Many contracts today specifically exclude such a role, and small businesses are often not in a position to force changes in that language. In summary, the problem of patent controls is widespread and getting worse, while the number of demand letters rises sharply each year. Fighting these trolls has a real cost, and we certainly urge Congress to take action to stop patent trolls and protect small businesses from the enormous costs of abusive lawsuits. Thank you.
Thank you, Mr. Scarvan. You are now recognized for your 5 minutes.
Thank you, Mr. Chairman, Ranking Member Schakowsky, and members of the subcommittee. I am testifying today on behalf of the Coalition for 21st Century Patent Reform, or 21C, a broad and diverse group of nearly 50 corporations, including 3M, Caterpillar, Eli Lilly, General Electric, Procter & Gamble, and Johnson & Johnson. For more than 100 years, our coalition's companies have played a critical role in fostering innovation. We invest billions of dollars annually on research and development to create American jobs and improve lives. Caterpillar alone has more than 14,000 patents worldwide, either awarded or in the approval process. Caterpillar is a company of innovation. We spend $8 million a day on R&D. Let me say at the outset that we believe bad faith demand letters are a problem, and we support crafting a balanced solution. Notification of patent rights are routinely presented in business-to-business communications to provide early notice of a patent that otherwise may not be known to the recipient. Patent demand communications can also start the clock running on patent damages. Recipients take these letters seriously in the design and development of new products and technology, oftentimes designing around the patent to avoid knowingly infringing another party's rights. In many instances, the primary goal of the sender is simply to prevent copying and ensure product differentiation within an industry. This is best accomplished by providing early notice, before monies are committed to substantial design and manufacturing investment, so that design arounds are more readily accomplished. Thus, legitimate patent demand communications serve an important role in advancing technologies, providing consumers more choices, and ensuring the efficient self-policing of patent rights, preventing patent suits before they happen. We believe that legislation on patent demand communications should address 3 areas of concern. 1, sanctions should be limited to those who send objectively false and misleading patent demand letters to large numbers of end users to extort settlements. Routine business-to-business communications should not be swept in. 2, clear rules of the road with objective guidance as to what such communications should and should not contain, not a list of vague and subjective good faith and bad faith factors for a court to weigh in determining what constitutes a bad faith patent demand letter. And finally, 3, a safe harbor should be provided that clearly states what all patent owners remain free to do. By safe harbor, I mean a provision clearly informing all patent owners that they may, 1, safely advise others of their ownership of or right to license or enforce a patent, 2, to safely communicate to others that a patent is available for license or sale, 3, to safely notify another with reasonable specificity that they infringe a patent, or 4, to safely seek compensation for past or present infringement or for a license to the patent. An appropriately crafted safe harbor will also help to insulate any legislation from challenge on constitutional grounds as intruding on protected free speech. Clearly, the sending of large numbers of objectively false, misleading, and deceptive demand letters needs to be stopped. The key here is objectivity. A laundry list with a large number of subjective good faith or bad faith factors to judge whether a demand letter crosses the line must be avoided. Such lists provide no meaningful guidance to the sender of a patent demand communication. Such subjective factors will spawn unnecessary litigation and are not likely to pass constitutional muster. Reasonable, clear, objective rules of the road are needed to guide normal business activities. rules that will not overreach and chill legitimate patent communications. We have seen a variety of bills working their way through the states. We have seen legislation covering what I will term legitimate patent demand communications, legislation not limited to end users, legislation without safe harbors, and legislation with vaguely worded factors that could sanction a perfectly legitimate patent demand communication. These differences in state legislation make it difficult, if not impossible, to provide clear guidance regarding what form of patent demand communications will be permissible nationally. In conclusion, the public will benefit from the adoption of clear, balanced, and uniform guidance regarding the patent demand letters that constitute unfair or deceptive trade practices. This can be accomplished by the adoption of exclusive federal legislation preempting state law directed to patent demand letters. Private enforcement under state unfair or deceptive trade practices laws should also be preempted and limited to Attorney General enforcement. Thank you, Mr. Chairman. I'll be pleased to answer any questions.
Thank you, Mr. Garvan. Mr. Solch, you are now recognized for your 5 minutes.
Thank you, Chairman Terry, and Ranking Member Schakowsky, and the members of the subcommittee. And again, apologies for my delay getting here. At NYU Law, I run a law and technology policy clinic. And for some people, that's a bit of a confusion. They're like, what do you mean? What is a pro bono clinic doing in the law and technology area? Well, one of the things we do is we get a lot of emails and phone calls from some of these people who receive demand letters and can't afford to hire a patent attorney. And they want to know what to do. And I can tell you from my experience, now over 10 years generally, but specifically 7 years running pro bono clinics such as these, that when I look at the letter, if it is some vague letter that doesn't actually specify what the accusations of infringement are, even sometimes what all the patents are and the claims at issue, it's hard for me to tell. It's hard for me to tell them anything. It's hard for my students who I'm supervising and trying to teach to be lawyers to tell them anything. And that's why I think this issue is very important, and I'm very glad the subcommittee is taking it up. Because this is not just about the shakedown. This is not just about the end user or the small business who receives the letter, but it's also about helping them if they can find help, to have the attorneys be able to advise them. It's one thing to defend a patent litigation, and we've seen a lot of statistics about how many millions of dollars that takes. But sometimes you can resolve these issues in good faith if you have enough information. So I just want to highlight that this is about an intermediate step as much as a final step in sort of looking at this problem broadly. Now, who are the people who receive demand letters? We've heard about a number of folks who are in very precarious situations when they receive these letters. My clinic and my students, we often will advise very small entrepreneurs in terms of the size of their operation. These will be application developers who are just writing something for the iTunes or Google App Store. There'll be mom and pop websites who are trying to develop their own content. Some of these patents actually cover content and the use of content and how it interacts with technology. And some of them will be community projects. We've seen a lot of work right now developing civic technology to try and improve roads, to try and improve use of data and look at the environment, improve water quality. They're all receiving patent demand letters too, many of them just as vague as the ones we've been hearing about. So in this role, there are sort of two problems that I think this committee could address. One is, as we've heard, that there are these vaguenesses that in some ways can even be deceptive when they're being asserted as a guaranteed infringement. So the patent owner will send a letter, say, you infringed this patent, but won't explain why, when I don't think even the patent owner knows, because this will be part of a campaign of general assertion, not specific to any individual or entity, but just we believe this whole group of people out there somehow infringe. And they assert it as if it's the truth, but they don't even know, and that to me is deceptive. And the second is, as we've heard, when they have no intention to sue whatsoever, that the threats made are intimidating and put the recipients in a position where they don't actually know what their options are. So when looking at this, I think we've just started to collect information about the problem, and I just wanted to say that efforts to try and collect more demand letters, such as trollingeffects.org, have been somewhat successful, but I'd like to see more information so we can understand the scope of the problem. But turning to the solution, I think that for me, these letters should be required to have specific allegations and information in them so that they can be, the recipient can look at them and assess what is actually going on, what are they being accused of. Several of the small entrepreneurs and coders and developers that I've talked to, they're actually technical people. They could actually try and figure this out, but they look at the letter and they say, I have no idea what they're talking about. And part of that is not just because the patent's vague, but because there's no information about what that patent owner thinks that this small coder did, or what the application that they put up on the iTunes store does that they think infringes. And so that information would be extremely helpful, and to require that, to require the patent owner to do their homework, to look at what this recipient has done, would be extremely helpful for the people that my students and I help. I think it would also help those who are recipients of good faith demand letters as well. Because let's say you do actually infringe the patent. Well, you should then figure out, are you going to design around it? Are you going to pay the license? Are you going to fight the patent because you believe it's invalid, even though you might actually fall into the claims? Those are legitimate decisions. And again, more information early on helps resolve this at a lower cost. The other thing is that our public patent system is a public notice system. And I just want to reinforce that as my final point, to say that it's as much about what the patent says when it's published at the Federal Register, but also when a patent owner is asserting it, they're asserting a public grant to them of a property right. And I think that the metes and bounds of that assertion and when you trespass on it should be as clear as anything else. Thank you.
Thank you. Mr. Chandler, you are recognized for 5 minutes.
Thank you. Chairman Terry, Ranking Member Schakowsky, members of the subcommittee. My name is Mark Chandler. I'm General Counsel of Cisco Systems. I'm here today to describe our experience with a new kind of scam. I'm talking about a ripoff that's based on a formula that's as old as the hills, but dressed up as patent infringement and innovation protection. The scam artists, as you've heard, send out thousands of letters not to me, but to my small business customers, and they file lawsuits in the hope of a payday not based on merits of the case, but on the fears of victims who just want a problem to go away. These victims, mom-and-pop stores, community banks, hospitals, car dealers, restaurants, aren't manufacturers of products. I do that. They're simply users like you and me in our private lives. As Cisco's Chief Legal Officer, I want to defend my customers, but we need your help in bringing some light, some sunshine to these nefarious practices. Cisco was founded 30 years ago to build products so incompatible computer systems could talk to each other. Today, we're the world's largest manufacturer of Internet equipment, from backbone switches to phone and video systems. Our annual revenue is about $50 billion, and we directly or indirectly provide jobs to hundreds of thousands of Americans. Our products are used literally by billions of people around the globe and are in tens of millions of American homes and businesses. We spend more than $7 billion a year on research and development. We hold over 10,000 individual U.S. patents. We believe in a strong patent system. But let me tell you a story which unfortunately is not unique. The story is not about patents, it's about using patents as the cover for a scam. Our story begins when a lawyer named Noah Whitley bought patents related to Wi-Fi from a great American chipmaker, Broadcom, and created an entity that he, I think, somewhat cynically named Innovatio. Broadcom, for its part, didn't want the patents anymore, since they were near expiration, had been broadly cross-licensed to other chip companies, and were subject to binding contracts requiring licensing on fair terms. But Whitley wasn't deterred by that. He and his lawyers sent 14,000 letters to small businesses, cafes, bakeries, inns and hotels, a children's health clinic, basically anyone that might use Wi-Fi in their place of business. Did he tell them what specific products they had might infringe? Might have. Not even a list of types of products? Nope. Instead, his lawyers just wrote, "I represent an individual who has suffered injuries as a result of your company's business," in claiming that the Innovatio portfolio covers all Wi-Fi usage. Did his lawyers disclose that a huge proportion of Wi-Fi devices were already licensed, and therefore no more could legally be collected on those patents? Nope. Instead, he told them that, that almost $1 billion had been collected in royalties on those patents, that thousands of companies had paid, without letting on that almost all those royalties were exclusively collected by Broadcom in cross-licenses that had little or nothing to do with these patents. Did they tell them that the patents related to industry standards and had to be licensed on fair terms? Nope. Instead, they told them, and again I quote, "We wish to license your company at a very affordable rate, far less than the cost of patent litigation. I can quote you a rate of less than $3,000 per location." This for patents that a court later determined were worth pennies per chip, and on equipment that these businesses had spent at most a few $100s to buy. And did they tell them that manufacturers, like my company, were eager to defend them? No. Instead, they wrote that equipment manufacturers have not stepped in to defend any of their users. This means we can still sue your client, and they cannot expect equipment manufacturers to aid in their defense. Finally, for those who had the temerity to resist, they enumerated thousands of pages of documents that they said needed to be reviewed, meaning a mountain of legal fees. Now, sadly, this isn't an isolated incident as General Sorrell, Mr. Briard, and others in the panel can tell you, but a dangerous trend. Let me close by suggesting 4 simple steps that would make it much harder to carry out these schemes. First, requiring anyone sending a more than 10 or some other number of patent demand letters to someone who is not a manufacturer or reseller of the product to file the letters in an online registry so they're easy to find. Second, require them to include a list of model numbers which they believe infringe, the fact that the manufacturers may be required to defend, and contact information for the manufacturers. Third, require any such letter to include the names of the real entities or individuals who own the patents. And fourth, require the letters to include a list of all previous licenses and whether the patents are subject to special licensing rules that apply to industry standards. While the FTC can already investigate and sue the most egregious patent scam artists, these simple steps will provide a basic level of transparency to protect innocent end users. Requiring full disclosure about what's being offered for sale doesn't violate anyone's free speech. I stepped into that case and I spent $13 million of my company's money to put a stop to this. The paycheck I get every other week says Cisco on the top of it, but every cent of it comes from my customers. That's why I'm here today. It's why I'm passionate about making sure they don't get ripped off by charlatans dressed up as innovators when they trust us to supply them with products. And, Mr. Chairman, if the predators are forced to come to me once they've disclosed what they're after, I can guarantee they'll get a fair fight. Thank you.
Thank you. Dr. Dixon, you are now recognized for your 5 minutes.
Thank you, Chairman Terry, Ranking Member Schakowsky, and members of the subcommittee. I appreciate the opportunity to come here today. My name is Michael Dixon. I'm President and CEO of Unimed Corporation. We're the technology transfer and commercialization entity for the University of Nebraska Medical Center. So my testimony today will focus on preventing illegitimate and deceptive patent demand letters without modifying the U.S. patent system or restricting university technology transfer offices. Universities are uniquely positioned here because we work with innovators at the university level as well as downstream partners that are trying to commercialize our discoveries. I'm going to have 3 main points today. 1, universities have an enormous economic impact. 2, strong enforceable patents must be preserved. And 3, ambiguous, vague patent demand letters are the lifeblood of patent trolls. And using a tool like the FTC makes much more sense than modifying patent law for a second time in 2 years. I'd like to start by offering a bit of background on the scope of the University of Nebraska Research and Technology Transfer. We're a proud member of the Big Ten and have a very active research enterprise. Over the last 3 years, we've invested $1.1 billion in research. 3/4 of that funding comes from federal sources such as NIH, NSF, and DoD. In that time, 625 new discoveries, new inventions were created, and that led to more than 150 licenses to companies. So that's 150 companies that are going to invest more money to bring these discoveries to life and make the world a better place. Furthermore, 20 of those companies were created in Nebraska, creating economic development and jobs for Nebraskans in high-growth, valuable companies. This licensing generated more than $37 million in revenue for the University of Nebraska, and that meant more money for research and more discoveries. Now, we're just one of many universities that undertake this. Last year, as a total, U.S. universities filed over 22,000 patents. They executed more than 5,000 licensing agreements and generated $2.6 billion in revenue. According to the Association for University Technology Managers, they added $385 billion to the U.S. GDP. This is a very big economic force. The economic impact is primarily based on patents. Companies are only interested in investing the millions or billions of dollars to bring these technologies to market if there's strong patent protection available. Quick story from our Med Center. As I mentioned in the testimony, the Levine needle electrode was invented at UNMC, and our industrial partner, Boston Scientific, brought it to the market. However, as the product neared FDA clearance, they found that it was necessary to enforce the licensed product against a competitor. The parties both followed the appropriate protocol, worked out their differences, and threw out a patent infringement suit. At the end, there was a cross-license, some payments, and the products were successfully brought to the marketplace. The system worked appropriately. The take-home message here is that any action must preserve patent rights and to continue to provide incentives for both large and small businesses that invest in technology that makes our lives better. There's a common theme with patent demand letters, and that's ambiguity. We've heard it already. Bad actors are trying to scare, deceive, inappropriately extort money under the guise of patent enforcement. And they often use a shotgun approach, peppering industry with hundreds of letters, often lacking detail. As a technology transfer office, not only do we work with startup companies who've received these letters, but we've also been on the other side, and we've had to enforce our patent rights. When we make that important decision to send a demand letter, we find it's critical to provide detailed information for the recipient. In addition to a reasonable standard, it allows the recipient to make informed decisions. In my written testimony, I offered 7 items that we'd have in a demand letter. Items 3 through 7 of this are often missing, as we've heard before, in demand letters. And I'll state, as a university, we're very conservative. We don't take litigation lightly. When we send a demand letter, we're going to do our homework. And so for us, it's very important that the recipient know what claims they're infringing and that we identify specifically what product it is that's infringing those claims. We want to make sure that the recipient knows who's suing them. Again, legitimate organizations don't hide behind shadow entities. If someone's infringing our patent, we want them to know who we are and what our patent claims. Our goal is to settle the disagreement and provide as much information as is critical for that to occur. Some trolls use marketing entities that have no subject matter expertise and cannot answer simple questions related in the demand letter. This, coupled with the shell entity, leads to a series of dead ends and frustration for small businesses with limited resources as expenses mount with no answers. Another quick story from one of our partners. They received a demand letter from a patent troll last month. While the letter identified the patent being infringed, it did not give the owner of the patent, the role of the organization contacting the company, a knowledgeable point of contact, or adequate time to respond. In fact, the point of contact turned out to be a marketing firm that was just established to send these letters through a shell company. The take-home message here is reduce the ambiguity associated with patent demand letters, and you'll reduce the power of the patent trolls. Thank you very much for your time. I look forward to any questions.
Thank you very much. And Ranking Member Schakowsky has a meeting, so we're going to let her go out of order and ask the first set of questions. So, Ms. Schakowsky, you are now recognized for your 5 minutes.
I appreciate that, Mr. Chairman. Is there anyone on the panel who thinks that it would be inappropriate for federal legislation, not getting into specifics, I realize some of you are coming, is there anybody who thinks that federal legislation is unnecessary? Okay. Attorney General Sorrell, you made a point of mentioning the issue of preemption in your testimony. I wondered if you could talk about that, though, and protecting the whatever states do.
We're currently in litigation under our State Consumer Protection Act for unfair and deceptive acts and practices in commerce against this MPHJ Technology Investment LLC. And as soon as we filed that action under our so-called UDAP statute, MPHJ removed the case to federal court and promptly said 2 things. One, that since this was in the patent arena, that the lawsuit is not only frivolous and filed for political purposes, but that we're totally preempted because patents are exclusively within the province of the federal government. And secondarily, that we lack personal jurisdiction over them for simply asserting patent infringement by sending these letters. And that's why we're asking when the Congress, if the Congress takes action here, to state clearly that AGs have legitimate, they're not preempted when there are unfair and deceptive acts and practices in the guise of an assertion of patent infringement, and that states are able to, without being preempted, enact statutes that prohibit bad faith assertions of patent infringement. So we're fighting that in federal court, U.S. District Court in Vermont right now, and given the fact that Nebraska, Minnesota, New York, and have
You
already,
said Wisconsin?
Wisconsin hasn't yet, but Wisconsin has just enacted a statute on bad faith assertions of patent infringement. But the AGs of those other states have taken action and in virtually each case been run up against this argument that you don't have any business here, you're preempted because this is patents.
42 AGs, you said, right?
42 AGs signed a letter to Senate leadership about matters that are actually just this week moving forward in the Senate.
Let me just go through a list of things. We've heard from a number of you things that should be in these letters and in the demand letters. If anyone thinks that they should not be in a demand letter, let me know. Raise your hand and I'll call. Okay. Identification of the patent being infringed. Identification of the owner of the patent. Contact information for a person who can discuss resolution. Identification of each claim of the patent being infringed. Identification of the infringing device, method, or service. Oh, okay, which one was that? Identification of each claim?
Yes, the identification of each claim. I think it was referred to earlier that certainly on behalf of the 21C, a number of the members have extremely large equipment, not readily accessible, information's not readily accessible regarding that piece of equipment. We usually rely on trade shows and perhaps advertising regarding certain features or possible benefits that seem to look, as a close industry, seem to look like something we have a patent on. So when I'm asked to provide an analysis or identify a claim against a product, I simply can't comply with that level of detail. I'm not in possession of that information.
Okay, it's on the record. Thank you. Identification of the infringing device, method, or service. A description of how the device, method, or service infringes. Identification of entities other than the patent owner who may benefit from enforcement. Identification of all entities that have been granted. Oh, go ahead.
I think you just have to be clear when you talk about benefit from enforcement that I think additional details forthcoming because there's been a number of proposals talking about how to identify that. Ultimately, you're looking for somebody that, you know, in a lawsuit, their damages, if there's a fee paid, they would take and participate in that reward.
Identification of patent company, parent, oh, I'm sorry. Identification of the parent company of the patent.
Again, I will say, on its face, the devil's in the details. On the face, that looks simple. I have heard other companies state at, for example, intellectual property owners organization, that in itself can be difficult to ascertain and provide correctly.
Okay, identification of all entities that have been granted a license to the patent.
Again, I think you start to get into a little bit of a burdensome situation with a company with tens of thousands of patents to understand exactly the entire licensing spectrum regarding that patent.
Okay.
Also on that one, I'll say from the university standpoint, if you're looking at non-exclusive licensing, sometimes those lists get very long, and sometimes companies' trade practices have some specific, they request some confidentiality that they've in-licensed that technology for competitive advantages, so that may become a little difficult.
Okay, this is helpful. Notice to the recipient that they may have the right to have the manufacturer defend the case.
I'm sorry, could you repeat that?
Notice to the recipient that they may have the right to have the manufacturer defend the case. And some factual basis, is that it? Yeah. Some factual basis for the licensing fee or settlement amount demanded, if any.
Well, again, I come back to, I think, the very basic elements. These all require additional, I think, discussion and explanation because these concepts can be very complex. But I think when you come to the very basic elements that should be the content of a patent communication representing a demand on something, the identity of person or entity with the right to enforce, the patent or patents forming the base of the demand, and the identification with at least one product, service, or technology. Those, I think, are the key elements. When you add to those elements, I think you're getting into some very definitional and perhaps burdensome, complex disclosures that really, at the point of time, are benefiting the assertion.
Okay.
Right.
My time has expired. I appreciate that. So we can inquire among all of you on writing responses to these suggestions or just proposals. Yeah. Thank you. I hear you on the burdensome issue.
All right. Well, let me ask, first of all, I think the nature of Ms. Schakowsky's questions were pretty similar to what I was going to ask, but it shows that if we are going to do, and I'd say it's likely that we would draft something sometime in the near future, what we're trying to figure out is what, if we draft a bill, needs to be in there. And it appears to us that we need to itemize or be prescriptive in what has to be in a demand letter. So that's why Ms. Schakowsky did a list of things that have been discussed that should be in there. Let me ask you just more generally, starting with you, Mr. Sorrell, or AG Sorrell, what are the characteristics that should be in a valid patent demand letter?
It shouldn't be any question of who's asserting the infringement. There should be evidence of investigation or in-depth analysis of this particular recipient's use of the technology that is allegedly violative of the patent. It should be clear if there are others with an interest in this assertion of patent infringement and who they are. There should be legitimate addresses, contact information for those asserting the infringement. If this patent has been the subject of a final decision, administrative decision, or a judicial case against the patent that's being asserted, that information should be reflected at least for starters, and the demand should give a reasonable amount of time for the person to respond, and there shouldn't be this undue burden thrown to the recipient of the letter to prove your innocence, if you will.
All right. As quickly as possible, Mr. Brouillard.
Yes, sir.
What points should be in a demand letter?
I would agree. I think it's obvious you can't receive a letter that simply says, hey, we did an investigation and found that you use our technology and here's a list of numbers. It needs to be clearly identified as to what is being asserted. What investigation was conducted? How do you know that we're violating your patents? And obviously, for someone like myself who's totally ignorant of this issue until this all came up about a year and a half ago, it has to be something more than simply a list of numbers. To me, I don't even know if those numbers were legitimate patent numbers.
Okay.
So
more specificity
in the claims that are being made.
Mr. Scarvan, I'm going to ask you the same question, but ask a little bit more clarity, because it does seem like you can identify what's being infringed. If you saw something at a trade show or an advertisement, you at least have a pretty good hunch that there may be an infringement. So
I can suspect, because I obviously can't see inside and I'm stuck with advertising. I do want to bring up a point that, we've discussed a few things, and I wanted to differentiate a bit, if you don't mind, the difference between business-to-business communications and the egregious actions I've heard here where end users are being targeted. And I will just say, in business-to-business communications, in patent demand letters, I think generally under the law, the way it plays out, less is more. And let me explain that. The number one concern prior to all this legislation that I have when I send out a patent demand letter, or any member of the 21C sends out a patent demand letter, is, does it contain enough information that the recipient feels immediately threatened, and they now have potential jurisdiction, they call it declaratory judgment jurisdiction, to say, look, this entity has threatened me. I cannot continue on with my investment without some certainty here on this issue. They brought the threat. I want to determine now, and all of a sudden you are in a patent lawsuit under what they call a DJ action. And so when we send out letters, they tend to be a first in a series of letters, and when people point to a specific patent demand letter, all I can think of is I have a series of letters that go out. None of them are the same, and they generally have these three things, but they don't have to, because I have different target audiences I'm sending this letter to. So I just want to make sure that this kind of correspondence, which I think less is more from keeping it out of the courts, doesn't include a lot of these details. And so, in answer to your question, I don't always have access to the information. I don't have that detail, and nor may I want to even put that level of detail or threat in my letter if it ends up inviting a DJ action and brings a patent suit in court.
All right. The other three witnesses probably will have to submit that answer in writing, and I apologize that my time has run out. So at this point, Mr. Welch, you are recognized for 2.5 minutes. No, Mr. McNerney, you're recognized for 5 minutes.
Thank you for the full 5 minutes, Mr. Chairman. I think it was a really good testimony. I thank you all for coming this morning. One of the things that I think was a matter of disagreement among the witnesses is how to enforce this. I mean, there's a pretty good agreement that the letters should have a degree of specificity, but as Congress, can we write a law that is flexible enough that it'll be effective, that the patent trolls won't be able to get around, and so on, or should we invest the FTC with the authority to do that in a way that would be effective? Mr. Dixon, I think you mentioned that you thought the FTC, how would we empower them, or do you believe they already have enough authority on in the existing statute?
I believe the FTC does have some authority here, and it would be wise of Congress to remind them that they do have some authority on some unfair trade practices. I think giving a little more teeth to the FTC and allowing them to look at these broad, vague patent demand letters, while still, I agree, allowing business-to-business communications to still occur and for business to transact that way, and not having that fall under this FTC action is very important. But I think giving them a little more authority would allow business to still go on, and for these legitimate actions to still take place while not affecting general patent law itself, which is the lifeblood of many of our businesses.
Okay, Mark, Mr. Chandler, would you like to comment on that?
You know, I would make one distinction. Mr. Scarvin referred to business, and I think what we're referring to here is letters addressed to end users. The end users may, in fact, be small businesses, and I'm not sure that some of the issues that Mr. Scarvin had with some of Ranking Member Schakowsky's enumerated proposals would apply in the case of an end-user communication, as opposed to when you're dealing with a competitor who's also a manufacturer, and where you have this dance that goes on in dealing with potential infringement allegations. In looking at the end-user situation, I think the space where federal legislation would be very helpful would be to establish clearly that it is an unfair business practice in those types of communications to end users to not include certain types of information. The FTC today can go after egregious misbehaviors who are misleading and deceptive, but once you set a very clear set of standards and also require transparency on those letters, manufacturers like me can step in. It almost becomes self-enforcing once you put some sunshine on these activities. And that's why there's a great opportunity to get something done here without creating a regulatory structure around it. What's really needed is daylight.
So you feel that Cisco can do a good job in defending your customers if you have the right tools to do that?
If we know this is going on, we can step in and do it. And if it's visible what's going on, these people will be forced to stop, because the group of people who are being attacked can also band together and take action. as Mr. Briard has pointed out. But sometimes it takes some daylight before you know that this is actually happening. So transparency is really almost a solution in itself here.
Thank you. Mr. Scarvan, one of the things you recommended was that a sanctions be imposed on bad actors. Wouldn't it be just easy for them, a bad actor, to put up another banner and continue on, even though the first label is sanctioned? They can go to another label and carry on their activities?
Well, I think what you say is correct. It's very, very difficult to capture some of these actors, and I think it's very difficult in capturing them with a single demand letter that does or does not meet, if you want to say, the requirements set forth in legislation. What I think works more effectively is to capture their behavior. And the behavior we're seeing, I think has been said today, is that these hundreds and thousands of letters that go to end users, and that's where you get to really focus in on and begin asking questions, because now you've got the behavior and the business model. I think people here are objecting to these hundreds and thousands. I think it was 16,000 letters nationwide. And that's where I think the FTC, uniform laws, and certainly uniform enforcement by the Attorney General, they act as a clearinghouse to identify this rampant behavior. And once you can see that behavior, now I think it's pretty easy to begin the inquiry into the entities engaging in that behavior.
Thank you. Thank you, Mr. Chairman.
Now recognize Vice Chairman of the committee, Mr. Leonard Lance. You are recognized for 5 minutes.
Thank you, Mr. Chairman. As I understand it, there are 5 or so existing state laws on this issue, and several other bills are awaiting signature by a governor, and there are as many as 19 bills pending in state legislatures. Given this situation, I'd be interested in the panel's view as to whether federal legislation is needed. Attorney General?
Yes, federal legislation is needed, and hopefully including in that legislation would be an express statement that the states are allowed to enact their own statutes against bad faith assertions of patent infringement and or to enforce their standard consumer protection acts.
Thank you. Others on the panel?
Yeah, I agree. I think that the U.S. patent law is federal legislation, and I think that anything that can be done to strengthen that legislation should be. In addition, I think to get back at the Congressman from California's comments, it's going to take a concerted effort on both the federal and state level in some cases to do that. And the last point I would make is that if you had federal legislation, then it's more uniform across all states rather than a hodgepodge for companies that operate in multi-states to try to deal with.
Thank you. Others on the panel?
And I agree, and I'm glad you brought that up, because not only is federal legislation needed, but we need uniform legislation that provides the same, if you want to say, rules of the road across the states. States certainly can enforce through the AG, but as far as having different state statutes to provide different rules of the road, different, if you want to say, private causes of action, some have safe harbors, some have no safe harbor. I mean, looking for a little bit more uniformity.
Thank you.
I could just add 2 things. One is that the patent system is an incentive system, and the Congress is in a great position to sort of balance those incentives. So if you want patent owners to do more to make sure that certain recipients get the information they need, you're giving them a patent and you can require them to do things. I think that's a nice balance there that doesn't preclude states, but it kind of gives you that power. The other thing is this bottom feeder model. This model where they just send out thousands of letters is premised on the idea that they don't have to be specific to the individual recipient. And I think that really needs to be in there somewhere, that core specificity, else they'll just redraft the letter in some other way.
Thank you. Others on the panel? Mr. Scarvin, you referenced safe harbor language in your comments. And in your testimony, you suggest that safe harbor language be included. do you have a specific idea as what type of model you would like regarding safe harbor? Is there a provision in one of the state statutes that we might examine? And if not, what would be an appropriate safe harbor provision from your perspective?
I think the most recent state that enacted a safe harbor and worked through some of the language differences was Illinois.
Illinois, yes.
Statute. And that was, and when you look at the safe harbor, I think it is helpful to look at it in combination with the cause of action being limited to those letters sent to the end users, and they have good definition for end users, including businesses, not for resale in that statute. And they also have not the subjective factors, but very clear false behaviors, along with very clear requirements of the patent owner, the patent number, and the general product or service it covers.
So from your perspective, we might examine the Illinois provision as a model for a federal provision.
Yes, yes, we have suggested that to other states.
Thank you. Others on the panel on whether there should be a safe harbor provision, and if so, what it should look like? No? Thank you, Mr. Chairman. I yield back 37 seconds.
Thank you. At this time, recognize gentleman from Vermont to ask questions to another gentleman from Vermont.
Well, and others as
Mr.
well.
Welch.
Thank you. I actually wanted to start with Professor Schultz. What options does a small business or startup company currently have when they receive one of these vague, threatening demand letters?
Well, so I think that if they're taking a rational approach, they want to think about this as, you know, first, are we doing what they say? Are we infringing some patent? And then they have a couple of options. One is they can challenge that assertion, right, in that they can get an attorney if they could afford one or get pro bono counsel. The second is they can decide to change what they're doing or design around that. And that's where the specificity really helps them. If they realize that it's only one small piece of whatever they're designing or doing, they can maybe change that and then maybe settle a little bit but move forward. And then the third is they can simply just pay to get out of the way, which is what so many of these are doing. So I think we want to give them valid choices, and the only way to do that is to have the specific information.
And then what's a remedy if there's an absence of specificity?
You mean in terms of what?
But for the receiver of that letter.
I mean, they're really stuck in a kind of quandary because they don't know what to do. They can't explore those other choices. They don't know how to change what they're doing. They don't know whether to challenge it because the allegations aren't there. So they're really left, the only rational choice left is to pay off the sender.
Okay, I want to go back to Mr. Sorrell and have you think about this question too, because I might want to get your point of view. But you've been really advocating that this is a consumer protection issue and that there has to be some role for the states, and it would be a mistake for the federal government to preempt. Just elaborate on that a little bit.
These efforts are so widespread that there's plenty of work for both federal regulators and state regulators. If you look at it from the drug trafficking analogy, the federal authorities typically take the cartels and the large dealers, and they leave the street dealers to the states. If we're looking at assertions of patent infringement, I believe the FTC does have authority, but it can't police this spectrum entirely, and there's a role for the states.
Do you, Professor Schultz, do you think that makes sense in terms of a practical way to protect innocent victims, like the Lincoln Street example, you know, a small nonprofit, and those options you laid out? I think for them, mainly, they are just terrified, and they can't make that phone call to the lawyer because they know the meter's running once that happens, and they hope it goes away, and it doesn't. So it seems to me that what General Sorrell is suggesting, that there be a consumer protection element, a local ability of local consumer protection division in an attorney general's office closer to the scene to be able to enforce or protect, I should say, the rights of some of these small businesses.
Oh, absolutely. I think that's an essential component. But I do think that since the patent law is federal, it's also worth looking at the incentive systems and allowing the option that you could provide consequences in the federal system too, because some of these things do go to court, and when they go to court, there are consequences to whether the letter was sent and what it said.
So if we provided consequences at the federal level, I mean, I like what you're saying about the incentives. It makes a lot of sense to me. would we want the benefit of local enforcement of those standards that we established here at the federal level?
Oh, absolutely. I think both can coexist and in fact, contribute to the same goal.
Okay. By the way, do patent holders, I'll stay with you, Professor Schultz, other than the trolls, routinely target end users? And could there be any legitimate reasons to send demand letters to end users?
So I'll say generally no, except that this term end user, I think we have to be careful because these are very clever lawyers, right, who run these companies, these trolls. And so if you define something too specifically in terms of one protected group, and they'll try and find a way around it. So I just want to be careful because, again, a lot of the folks who call my clinic and are looking for pro bono assistance are people who develop apps, and they're like 2 or 3 small, it's a small business, 2, 3 people just trying to create something to put up on the iTunes or Google Store or whatever. They're not end users in a sense, except they're end users of the internet, right? So I just want to make sure that if we're going to cover people who are using standard technology, it's not just only the physical stores, but it's also anyone who kind of has using a product or service from someone else.
So I'll ask the whole panel, I've only got 18 seconds. Yeah. Well, I guess I won't. Well, the question I was going to ask, but then I'll yield before there's an answer, is what evidence do we have about the effect of patent trolls on suppressing innovation?
All right. That would be a great answer for a written question.
All right.
That we will submit. At
I
this
yield
time,
back.
Thank you. Gentleman yields back. Recognize the gentleman from Texas, Mr. Olson, for 5 minutes.
I thank the chair. And first of all, I don't like the term patent trolls. These aren't patent trolls. They're patent bullies. Like the bully on the playground in 3rd grade, the bully every Monday comes to school, threatens to beat you up if you don't give him his lunch money. These are patent bullies. And thinking out of the box on how we stop this behavior, in my home state of Texas, again, not directly applicable, but they did something in 2011 called basically loser pay. My state senator, Joan Huffman, got that thing passed. It's been going on for about 3 years now. And what they've done, not so much in patent protection, but just sort of legal protections for some of these frivolous lawsuits, they basically empowered the trial judge to say, this is garbage. Throw it out. He gets the initial filing, say, frivolous, done. If that doesn't work, okay, how about I send it up to if they're going for the home run? We know it's really bad, but we're going to want to take that shot, maybe knock that thing out of the park. And that's the case, I can send it straight from my court to the appellate court, get this taken care of quickly. So again, the aggrieved party is not paying legal bills on and on and on. Also for the small guys, if it's less than $10,000 or $100,000, expedited civil action procedure. And so I ask all the panelists, is that something we should look at? I mean, I know there's lots of pros and cons, more federal involvement, preemption, that type of stuff. But again, how can we take this hammer away from these patent bullies? It's not patent trolls.
If you don't mind, I'll take the first shot at it. I certainly believe that part of the legislation should include some opportunity for the party that's been aggrieved in this situation to have their costs reimbursed. I suspect if I got a letter from Caterpillar, I'd pay attention. But when I get a letter from an entity I don't know that just lists a whole bunch of numbers, clearly for someone like us or any small business to defend, we've been told it's $1 million cost to defend a patent lawsuit. We're certainly not in a position to do that. And I really do believe that if a patent troll or a patent bully ran the risk of having to reimburse someone, they'd think twice about doing it in the first place.
General Stroll, any comments, sir? And my parents are voters in Vermont.
In the Vermont statute, it allows for awarding of attorney's fees, but again, to recover, you have to establish that there was a bad faith assertion of patent infringement. And I think some of the concern about AGs getting involved in this arena is, are we going to sort of muddy the waters? Speaking for myself and pretty comfortably for the rest of the AGs, we do not want to try to get in the middle of a fair fight between two companies where it's a reasonable fight as to whether this patent exists and what it controls. We're really trying to deal with the bottom feeders, and we think that there should be the current federal standard of the awarding of fees in patent cases ought to be eased so that they're awarded more frequently. I'm not prepared to say that loser pays in every case. That might be an overreach there.
Mrs. Carvin?
Well, I would just say that some of these concepts, you know, I think they can work conceptually. Generally, they fall down if you try to apply them just to one side of the coin, so to speak. They have to be available, similar to bonding, to both parties, because you're predetermining that somebody actually is the bully ahead of time. It all comes down to what actually is going on. Certainly wouldn't want to be one-sided and attach that type of penalty to a legitimate patent communication.
Yeah, it sounds like the bully becomes the bully, maybe, in that situation. Professor Schultz, any comments, sir?
Yeah, so I do think that, I mean, many of the efforts that are being explored in Congress right now, I think, are comprehensively looking at the problem, and I think that linking them together and making sure they all fit well together is good. So I think that, for instance, the type of demand letter or the kind of information that is or is not shared and how vague and how deceptive it is may well be appropriate factors to play into a fee award, right? Or to, say, an adjustment of whether damages are available for willful infringement or not. These kind of things, I think, are linked and are important. But I do think that it needs to be dealt with, the whole problem needs to be dealt with on a couple different levels.
Okay, Mr. Chan, run out of time, sir. You got one more swing, take it out of the park.
You know, the Innovation Act that passed the House with overwhelming bipartisan support includes a provision for some cost bearing when a case is completely unreasonable. In this particular type of problem that we're talking about today, though, it's unclear how that plays out, because these things don't generally go to litigation, because they get settled because you have someone who's using Wi-Fi in their business that is told you can spend hundreds of thousands or millions of dollars to defend this, or you can just pay us $2,000. So
yeah, the bully.
The promise of that might be illusory, and we just need to, I don't call them trolls because I don't like to demonize my adversaries. I would just say they're like rats running through a maze, and we need to take the food away at the end, and then they will stop going through the maze. And that's a systemic issue that we can address that won't result in a lot of litigation and awards at the end of it.
Thank you. About time, Mr. Dixon, very briefly, sir. Mr. Chairman,
Thank you, Mr. Olson. Now recognized gentleman from Illinois, Mr. Rushford.
I want to thank you, Mr. Chairman, and it's been quite interesting. I want to thank the witnesses for appearing before the subcommittee. Earlier, Congressman McNerney asked about the FTC's authority, and Dr. Dixon mentioned that the FTC already has authority and could be encouraged to use that authority. Perhaps, Mr. Chairman, we should encourage the FTC to be more aggressive on the issue of patent trolls, be they bullies or rats, or however you want to define them. However, I'm interested in understanding what additional authorities the FTC could use in this space. For example, General Sorrell, the FTC does not have authority currently to collect civil penalties under Section 5 for unfair and deceptive practices. General Sorrell, shouldn't the FTC be able to bring cases for more than just injunctive relief and also hit these bad actors, be they rats or trolls, directly in the pocketbook? And also, are there other authorities that would be helpful, such as APA rulemaking or declaring certain actions to be, quote, per se deceptions? For example, if a demand letter does not include the patent number or numbers, could they just be, based on that, be declared per se deceptions? What do you respond to this, General Sorrell?
Thank you. In my view, the Federal Trade Commission does have authority in this arena right now, and that's in part evidenced by the fact that MPHJ technology, that when the Federal Trade Commission started investigating MPHJ technology, it turned right around and it sued the Federal Trade Commission to halt the investigation. That being said, I would suggest that there be a communication to the Federal Trade Commission about the other issues that you raised, whether they think that the Congress might underscore or enhance the authority that they currently have. My concern is that if legislation just speaks to enhanced authority for the Federal Trade Commission and you don't speak to the state's authority to enforce our statutes, it will be argued that you were consciously trying to cut the states out of the equation.
Are there any other witnesses who want to comment on increasing the authority of the FTC? Mr. Chairman, thank you. I yield back.
Thank you, Mr. Rush, and I appreciate your input. Now recognize the gentleman from Ohio, Mr. Johnson.
Thank you, Mr. Chairman, and I appreciate the panel being with us today. For all of you, and you can answer in whatever order you would like, what role should the Federal Trade Commission have regarding patent demand letters? Anybody want to comment?
I think I just answered that question, so I'd pass it down the line.
Well, so I'll just add one thing, which is that I do think this question of understanding the problem, I think we have a pretty good handle on it. But I think, for instance, one of the questions is, what are the subpoena powers of the FTC in terms of getting access to the letters that a particular entity might have sent out that they're not aware of, things like that. And I do think that it's, if we're going to support the FTC investigating, or state AGs as well, that they do need to understand the problem, and they do need to see the letters that have gone out and the practices of the entity. So I think that information collection is an important aspect.
Okay. Mr. Chandler?
Speak to the...
Oh, I'm sorry. Go ahead. Mr. Scarvine?
Yeah, thank you. I speak to just the consistency and uniformity and ensuring that consistency and uniformity and providing that clearinghouse function to identify the bad behaviors, giving comfort to a company that sends a handful of demand letters that they won't be brought into a private cause of action at the state level by perhaps a recipient who wants to play mischief.
Okay. Mr. Chandler?
Thank you. I think the role, the FTC has the authority today to go after for unfair business practices the most egregious cases. The opportunity that you have in legislating on this is to set some very, very clear standards for what a demand letter to an end user or a small app developer would have to include, so that you have an immediate step that the Commission can take to try to demand transparency. So rather than creating a regulatory structure around the ultimate enforcement action for the underlying acts, by making very clear what a demand letter has to have, I think you stop automatically a lot of this activity, because these entities that are doing this can't stand to have the sunshine expose what's going on. And just setting that standard for what needs to be in the letter, I think, will go a long way towards solving the problem itself.
Okay. Mr. Dixon, in your testimony, you distinguished between letters with allegations of infringement seeking compensation versus letters marketing inventions seeking investment. How are these letters different from each other, and what do you say that distinguishes them, or what do the letters say that distinguishes them?
So I think that this really gets back to the business communications that we would have as a university when we're trying to market our technologies. We're trying to incentivize investment, but oftentimes within these letters, we're identifying intellectual property that we own, and we're letting a company know that they may be interested. For example, I've got a cancer vaccine. I know Eli Lilly works in cancer. I'm going to send them a letter saying, would you be interested in developing this technology? I think the major difference here is that patent demand letters will contain the threats of litigation and often require that license. Now, as has been stated earlier, these trolls are very bright. And so one of the things I think that will be difficult is to craft the right legislation that will prevent the troll-like activity while not stopping these typical business communications that are vital for us to continue on. Because universities and companies need to send letters to one another identifying potential IP that we might want to cross-license or develop together. We want to make sure that that does not get caught in any sort of FTC regulation that slows the pace of innovation and development.
Okay. All right. Mr. Scarvan, you stated you want a safe harbor to preserve your rights to put companies on notice. What is the difference between the manner in which you communicate your patent rights and the manner in which a patent troll communicates his alleged patent rights?
Well, I think there's a whole spectrum of, and again, using the word patent trolls, but maybe better word is someone that's abusing the patent demand system or patent demand letter. I think any patent holder who's engaging in good faith communications is entitled to those safe harbor rights. When you start talking about an abuser and somebody that's acting in bad faith, objectively bad faith, false statements, then that person is not entitled to those safe harbor rights because they're not acting in good faith. And so the difference really isn't so much the label of the person exercising the patent right, it's whether or not they've engaged in this abusive behavior, and they're not entitled because they've been acting in bad faith to those, if you want to say, good faith rights that everybody has.
Okay. All right. Thank you, Mr. Chairman. My time has expired.
Thank you. Now recognize gentleman from Illinois, Mr. Kensinger, for 5 minutes.
Well, thank you, Mr. Chairman, and thanks for holding the hearing. And to all of you, thank you for coming out. Especially nice to see the folks from CAT here. It's good hometown or good home state company. I'm grateful for the panel's insight on these issues of the abusive patent demand letters. In my office, we've heard from several consumer groups, realtors, credit unions, and banks, and they share a common message, which is patent demand letters are often deceptive, confusing, and intimidating. It is certainly concerning that some entities are purposefully misusing patent demand letters. These tactics hurt job creation, hinder innovation, and place a significant financial toll on consumers, businesses, nonprofits, and other actors within the economy. As we consider these abusive tactics, and as we've had a lot of discussion today, it's important to keep in mind that demand letters do serve a legitimate purpose in the patent system, and any reform should ensure legal patent holders' rights are protected. With these considerations in mind, I have a few questions I'd like to ask. I'll start with Mr. Scarvin. You probably know the Illinois bill better than I do, but could you tell me any shortcomings that the Illinois bill has, and then where the federal government would have a role in essence, pouring cement over that in order to protect the rights of companies?
Well, shortcomings. I actually applaud Illinois for coming up and crafting a compromise solution.
Well, I guess let me rephrase shortcomings instead of saying where would you believe that in Illinois the federal government then would need to step in after Illinois has done what it's done?
Where would well, looking at the Illinois language, I would like to see, if I'm answering the question correctly, I would like to see any federal legislation, any rules put in place to be consistent with the Illinois language, because it again comes to, I think everybody agrees, it's those communications that are sent widespread, hundreds and thousands to the end users, that are clearly the abusive practices that people seem to be keying in on. And so that language in the Illinois, I think, is pretty key. And I think people have mentioned that definitional language is important to understand that. And when questions have come up on the Illinois legislation, it's usually around the definition of consumer and person and, not for resale type language that's inherent in that bill.
So then for the whole panel, with all your stakeholders, Illinois has its language. Let's say Pennsylvania comes up with its language. Iowa comes up with its own. What's the concern with how you practice your craft in terms of states that have all kinds of different languages not consistent with, for instance, Illinois or no federal provision? And we can start on the very left, sir, if you want to go. If you guys have any thoughts on the varying state proposals.
The Vermont statute is for bad faith assertions of patent infringement. I'm not familiar with the specifics of the Utah, Virginia, Oregon, and Wisconsin laws, nor the others that are being considered. But to the extent that the standard is bad faith, then I'm not of the view that companies that make good faith patent assertions of patent infringement have a problem.
Okay.
Yeah, clearly, I think from our point of view, patent law is federal law. And so, as I mentioned earlier, I think it's important that there not be a hodgepodge of legislation at state level that starts to countermand things that would be good practices for companies that do operate on a multi-state or multinational basis, such as we've heard today from Caterpillar and Cisco and others.
Yeah, Mr. Scarvin, if you could talk to specifically how it would affect your company if you had varying state laws.
Well, I actually asked that question specifically with the folks in my group, and with that wide variety, you would literally have to have a spreadsheet hanging over your desk and understand what states cover what and what the penalties are. And at the same time, you would have to have an understanding of exactly which states are in play, because many recipients in our line of business are multifaceted state participants. In the end, I think we would just be sending out fewer letters. It would absolutely chill our ability to send out any communication. I just want to reinforce that there isn't a magical patent demand letter that suddenly appears at some point in time in the conversation between business to business. It's a series of communications where you're trying to invite dialogue and you're trying to address this issue and get more information, find out more, and move toward a solution all outside the court system.
Thank you. And any of the other three gentlemen, I only have 40 seconds. If any of you three have anything to add, please do.
I had a really quick comment. I think one of the dangers here is putting back on the states the requirement of determining what's legitimate and who's lying, because within this there's a pretty gray spectrum of entities that are maybe stretching what their patent claims may actually be. And so that's what our federal court system is designed for. And so one of the difficulties, I agree, the bad faith need to be taken care of, but there becomes a gray zone of what do the states, where do they exert there, and we don't want the state attorney generals having to do patent claim charts all of a sudden.
Right.
We want that done in federal court.
Okay. With that, Mr. Chairman, thank you. I yield back.
Thank you, Mr. Kensinger, and we have no other witnesses, so I have to do a little business here before I can adjourn this. And so we have statements for the record, and I ask unanimous consent to insert into the record these papers and letters from SPAN Coalition, Credit Union National Association, Independent Community Bankers of America, National Association of Federal Credit Unions, and National Retail Federation. This has been vetted on both sides. So hearing no objections, so ordered into the record. And I want to thank all of you for being here. It was a very narrow, intellectual discussion, and I think it was a really good discussion and very helpful to us. And I really appreciate all of your efforts and sacrifices to be here today to help us now as we will sit down and start figuring out how to draft a bill. You are now adjourned. Thank you. Oh, one last thing for the record. We have 14 days to submit records or written questions to you. I would appreciate maybe 14 days to return the answers to those questions. Thank you. But no one's going to come after you on the 15th day. Just